Okay. So good evening, everyone. I'm glad, you guys could join us. People are going to trickle in, so I might have to repeat myself later, but tonight we'll be presenting on animal law, your tenant rights within housing, emotional and service support animals. And tonight we'll be presenting on that is John Mayer, an attorney who specializes in this. And we are so glad that he will be able to, present with us tonight. He has presented at our annual housing conference previously. So, John, you can start. You can take it away.
Super. Thank you, Jakari. Thank you, Palante, and thank you, Alicia Vasquez, who I've known for several years. I'm grateful for all of the animal people in the audience. This is a great opportunity to discuss important family members, non-human family members. So thank you for coming out tonight. Can we queue up? I'm going to work from a series of PowerPoint slides, and I'm going to address my presentation as quickly as possible. I'm going to go through slides related to service animals and emotional support animals. And we're going to start with some general background stuff. So next slide, please. Okay, so before we get to disability law, service and emotional support animals, we're going to discuss common lease and renewal animals and clauses. Obviously, many leases say no pets or have a weight limit or restrictions such as service elevator or DNA testing of your dog poo or something in some extreme yuppie condos. The important thing to remember is that your landlord, if you have a rent stabilized apartment, your landlord cannot impose a no pets clause after you've signed a lease without one. Next slide, please. Okay, pet fees and deposits. Landlord can charge them. The takeaway point from this slide is that if you have successfully applied for a service or emotional support animal, your landlord cannot charge you a premium for that. I have had several cases where landlords have tried to do just that. Oh, I'll let in your service animal if you pay $200 extra a month. It's nothing short of blackmail, and it's illegal, and your landlord could end up in federal court. Next slide, please. Pet restrictions on private and public housing and co-ops. NYCHA has this weird thing where since it gets federal money, it can provide restrictions on pet dogs of 25 pounds or less. That applies to pets. Service animals and emotional support animals, ESAs, are not pets, so they're not subject to this. There are all sorts of other crazy restrictions on animals. This is, you can look at the slide, or I might make the PowerPoint available after the presentation. If you're interested, email me. Otherwise, next slide, please. Pet surveillance. If you have an animal, make sure your animal behaves in public and transit. Be respectful of your fellow tenants and building staff and licensees upon the premises. You will probably be photographed at one time or another by your landlord. There's a lot of increasing amount of surveillance. Some leases call, like I said, for DNA swabbing of your animal. And if they find, dog poo or cat poo anywhere on the premises, they will do a DNA testing thing, just like out of Law and Order or something, and try to tie you to it and fine you or bring a nuisance case against you. Get ahead of that by being a good neighbor. Next slide. More of the same. We're not going to go. This is just an actual lease clause from some yuppie building in Brooklyn. It's spreading. I've seen this at a building on 120th Street where I had a case involving COVID access. There, the landlord was making everybody sign this lease clause. Next slide. Service animal or emotional support animal. Well, it's not species based. With some restrictions. The idea here is that a service animal has to wear an identifying tag or harness and receive specific training, and an emotional support animal does not have to do either of those things. So anyway, I also like to throw in a cute pet slide every now and then to keep pace. Next slide, please. Oh, which slide are we on? Okay, great. What is the law of service animals, ESAs in New York State. This is, they're obviously federal, state, and city laws that we'll talk about for our purposes and yours. The ones that matter the most are federal and state laws. The city laws are more expansive, but they apply in a forum, the New York City Human Rights Commission, which has a great name and is very expansive, but it doesn't get what you want out of this necessarily, which is the right to bring your animal and damages, punitive damages against your landlord for discriminating against you and your animal on the basis of your disability. So what is the law of service animals? Here's the actual section from the law. It's not very interesting. It's a block of text. It just gives an expansive definition of what isn't allowed. You're not allowed to discriminate against anybody with a disability who has a service animal or an emotional support animal in New York. And there are enhanced penalties for dealing with specific service animals, such as seeing eye, guide dogs, and other types of guide dogs, such as seizure alert guide dogs or hearing guide dogs. Next slide, please. Service. Okay, so here's a breakdown of the relevant law in summary. Federal laws that matter: the Fair Housing Act, the Rehabilitation Act, and everybody knows the ADA. The ADA does apply to all housing receiving federal funding, which includes NYCHA. So if you're a NYCHA tenant and NYCHA gives you a problem, and I've had NYCHA cases where they've done just that, then that's something that you have a right to go to court on. I think we've lost the slides. Can we head back there, please? Hello, gentlemen.
One moment.
Of course, we apologize for any technical issues.
While Robert's pulling the slides back up, remember, if you guys have any questions, you can drop them in the Q&A section and we'll be sure to answer them. Thank you.
Okay, so we're previous. Great, service and ESAs. Okay, so basically the takeaway here is there are a whole bunch of laws. Many of them have alphabet soup acronyms like ADA, FHA, RA, etc. You just have to remember that you have the most bang for your litigation buck in federal court and state court. And that's probably where you should be. And we'll talk about administrative complaints, which you can bring, but they're really feel-good measures that don't get you the relief for the money that you need. They're just easier because they're sort of file and forget, but what you get back is not as important to everybody. Anyway, so let's continue on. It gives the FHA definition of what a provider can't do. That's where the cursor, at least my cursor is. It's the third block down. The New York State executive law is known as the Human Rights Law and covers ESA and service animal issues. And the New York City Human Rights Law is part of the administrative code, and that also covers these issues. I will mention there are other issues covered by the ADA that the FHA does not cover regarding access of service and ESAs and public accommodations, such as if you want to bring your dog into a restaurant or a store or something, and your dog is an ESA or service animal. That's not a housing issue, but you still have certain rights in that regard that should not be trampled on. So that's a separate issue. Tonight at Palante, which again stands for People Against Landlord Abuse and Exploitation, we're talking about housing issues. So let's go to the next slide and continue on housing aspects. What is an assistance animal? Here's the definition. It's a federal definition: that works, provides assistance, or performs tasks. The feds use all these weird phrases that are inconsistent. They use assistance animal instead of saying service animal, which is a defined term, or emotional support animal, which is a different defined term. And they also use service animal to mean both service animal and ESA, which mean totally different things. So it depends. You have to really have an animal lawyer represent you, because otherwise none of this makes sense. And only after years of reading these very boring statutes in the Code of Federal Register and New York State executive law does it all begin to make sense. Otherwise, it's just a massive inconsistent laws. Let's go to the next one, please. Service animals. Here's the difference between the two. Service animals have to be individually trained to perform a specific task. They don't have to be dogs. They can be a miniature horse, a guide dog, certain other types of animals, like a parrot or something. But the idea is that they've gone through a course and they're certified. There's some rigor to it. You can't just say, I need a service animal and I'm going to go to a pet store or adopt something or get an animal. This, for example, say you have a severe condition that requires a service animal to be trained for you because of traumatic abuse or, or blindness or something. Your dog will have to go through an 8-week course at St. Hilda's, and you'll have to be on site for 4 weeks of it, working with the dog. And it's very important that the key to qualifying as a service animal is that your animal has specific training designed to help your specific condition. And that only works for you and nobody else. They also have to be registered with the service dog organization and wear a harness or tag. These are not mail order organizations. These are very hard. There are only 2 of them in the New York area, the Delta Society and St. Hilda's in New Jersey. And it is like boot camp to get through them. Next slide, please. Emotional support animals. There's no training standard. If you have a qualifying disability, you have to get it, and we'll go into this in some detail. You have to get a specific medical or psychological note. Don't waste your money getting it from one of those online sites or registration mill. You want one that gives specific facts correlating you and the animal. It has to say what your disability is, who the animal is, and why the animal is a therapeutic measure for your specific disability. And if you don't have a disability, you will never qualify for an emotional support animal. It is only to help people out who have genuine, legitimate medical or psychological conditions. Next slide. Must I disclose a service animal prior to signing the lease? No, you do not have to. Sometimes you will be asked to disclose that. It's up to you if you do. We'll get to the story of a client who did and what happened there, but no, this is your business. If you do want to bring an animal onto the property, you do have to apply at some point to have the animal listed as an emotional support animal. You don't have to seek advance notice of anything for service animal because they have enhanced standing over ESAs. Next slide. Okay, I want to get a service animal. My lease has a no pets clause. Well, this is a no-brainer. Your service animal is not a pet. It's a working animal. And don't let anybody tell you differently, and they're treated differently. And if you are ever involved in a litigation, don't refer to your service animal or ESA as a pet. It could undermine your case. Next slide. How do I apply for a service animal? We've discussed some of this. You have to have a qualifying disability or handicap. I've gone over the standard for new animals. You don't necessarily have to do that. Next slide, please. What is a qualifying disability? So the feds call it a handicap under the Fair Housing Act, the FHA, and it's kind of an antiquated and somewhat offensive term to say someone is handicapped, but that's what the law says. It really means the same for all practical purposes as disability, which is the term that the ADA, Americans with Disability Act, uses, which means exactly the same thing. And what does that mean? It means some physical or mental condition which impairs the normal activities of everyday life. New York State has a different term. It's more restrictive, and New York City has the most expansive term at all. It can be almost anything in New York City, and that helps you out a little bit in New York City in terms of getting applying or getting a status to keep a service animal. It doesn't help you out as much if your rights have been violated. Next slide, please. Service and reasonable and emotional support animals, reasonable accommodations. So let's talk about that. That's the first step. you can't, you can bring a service animal in and say, I have a service animal, but you do still have to fill out paperwork after that if your landlord challenges you. But there's nothing stopping you from walking in the door on day one with the service animal. For an emotional support animal, it's a little more tenuous. You can bring one in and later claim apply late. The law doesn't say you can't do that, but you are required to apply at some point for a ESA certificate. And how you do that is you give certain information to your landlord. It's a litigation battleground as to how much is intrusive and how much is required. All you really have to do is disclose the nature of your disability. You don't even have to say exactly what's the matter with you or what caused it. The name of your animal, a description of your animal, and that you have a therapeutic purpose for the animal, which has been prescribed by a physician or psychologist or nurse practitioner. And the laws are pretty consistent between federal, state, and city. We're not going to read them out loud. That would be too boring. Next slide, please. Service and ESA's prohibited acts. This is what a landlord can't do. They can't demand they can't demand that you go to see the landlord's shrink or doctor. They can't just deny you out of hand. They can't place a breed or weight restriction on. They can't refuse to renew because you have an animal. They can't harass you. I've had that happen. That was really a sick case. They can't like disparage you and all that other bullying, intimidating stuff. It doesn't fly here. And if your landlord does any of this, they're going to find themselves in federal court, and they can try explaining to a judge while they were laughing while denying you your legal rights. Next slide. Law applies to housing. Okay, so there are certain exceptions to where ESAs and service animals apply, and because obviously no one can bring a guide dog into like a rocket ship or something, but those are few and far between, and you're not going to encounter them in Harlem where I live, because pretty much all housing is multifamily housing, which is covered by the FHA statute as well as the New York State Executive Law Statute. This is up there in case there's anybody who's statute specific in the audience or has an interest or is a lawyer or something, or animal advocate that deals, or disability advocate that deals in these issues, just so you have the statutes. Next slide, please. Obligations of landlords. You have to request your reasonable accommodation, and that you can't just outright refuse to make a reasonable accommodation without engaging in an interactive process. We're going to get to that pretty much next. Next slide, please. What is a reasonable accommodation request? It's basically what we discussed: filling out a form, disclosing the nature of your disability, your therapeutic need, and the animal. Next slide. Making one, this tells you how. It's usually filling out a form. The form becomes very important if you end up suing, and I or somebody else, I'm your lawyer, we will use this as evidence in court. And the key point I make here is number 4, it's an interactive process. You apply and the landlord can go back and forth and ask you certain legitimate questions. They better ask no non-legitimate questions, and you have to respond and be cooperative and try to show that that your ESA or service animal is not going to be a threat. For example, you can't bring a lion into an apartment and say, this is my emotional support animal. The statute doesn't mention lions, so I must be able to bring one in. That doesn't work, because a lion would be a danger to others and therefore would fit within the exclusion to the statute, even though it doesn't enumerate lions, for example. So also hippos, maybe a hippo wouldn't be dangerous, but you couldn't get a hippo or an elephant through the hallway. So that wouldn't work either.
I think hippos are considered pretty dangerous.
Possibly. Anyway, next slide, please. Interactive process, we just discussed that. So next slide.
Wait, John.
Yes.
Would you want to answer 2 questions really quickly, or no?
I'd rather do it at the end of my presentation, because I'm trying to rip through my presentation. Happy to take all comers. Landlord defenses. Basically, this is a list, and the bottom line is it's a difficult standard service and ESAs that are legitimate. Next slide, please. Robert, next. Okay, deciding to file. So I've got about 5 slides here where I outline all your different administrative and legal options here. Basically, it comes down to you can file a federal lawsuit, a state lawsuit, or you can file a HUD administrative proceeding or a state administrative proceeding or New York City administrative proceeding. That's 5 different options that you have. I always say for 95% of these cases, take the federal lawsuit because you'll get a wider range of relief. You have the damage awards are larger. You can get punitive damages. You can really seek to hold your landlord accountable and stick it to them. And there's a lot more weasel room in administrative proceedings before the city of New York and New York State than in federal court. So I litigate in all forums, and I prefer that the cases be brought where possible in federal court. Where the facts are fuzzy, I go to state court. Next slide. This is more of the same. This is file a complaint in HUD. The key thing here is HUD will take your complaint for free, and they will investigate for like 6 months to a year and then make a determination. And then they either tell you you have no case, but can still file a private lawsuit within a year, or they will have the U.S. attorney file for HUD, but not for you. It's key to understand that if you file a HUD administrative case, HUD is representing HUD as an aggrieved party and not you as a person seeking damages. They will seek to get you a fine, but they won't get punitive damages or all the other damages to which you're entitled. Next slide. New York State lawsuit. It's like we said earlier, it's slower. It's better if the facts are fuzzy because the evidentiary rules are less than in federal court. That's about it. Otherwise, stick with the feds. The next slide, please. New York State Division of Human Rights complaint. Just don't do it. It's like a migraine headache waiting to happen. No evidentiary rules. Everything is in really conservative hands, and they assign an attorney to represent New York State, but not you. It's the same thing with HUD, where they're out to like correct a wrong, but not to get you money for your suffering. So don't go with these people. Next slide, please. New York State Human Rights Commission, same thing, just don't do it. Next slide.
Before I just didn't want to interrupt, but we have a Joaquin with his hand raised. Joaquin, please feel free to post your question in the Q&A or in the chat.
Yep. That's true. People, I'm trying to just get through my slides, and I'm happy to take everybody's questions at the end. So the kind of the last section I'm going to go through, and then we'll get to your questions, is a case I had called Chen versus Glenwood Management. Glenwood Management is a regional portfolio of homes. They operate everything from luxury to subsidized so-called affordable housing. And they're not the nicest people in the world. My clients, Vera and Ed, an immigrant couple from Russia, they applied to rent an apartment at a Glenwood property. They were handed a form. Do you have an animal? They disclosed they had an animal and Vera's disability, and that their animal Capo weighed 120 pounds. He's a Cane Corso. Anyway, management went back and forth. We'll go through some of the representations in one of the further slides, but management basically claimed that they were complying with the law, but also told my client it would be better if my client withdrew their application because the size of the dog would cause problems for the other tenants. And those problems were that they'd have to listen to the dog make grunting noises, and that other people would be worried about the size of the dog. So I filed the lawsuit in the Southern District of New York. I got the New York State record settlement of $100,000 from my clients, which stands as the largest individual settlement, plus a stipulation requiring, and this felt really good, requiring Glenwood to post signs, promise not to do this, and make all the executives and staff go to training on how not to discriminate against people with disabilities. And the best part is they previously had to do the same thing in a non-animal lawsuit where they were discriminating against people with physical limitation disabilities and wheelchairs by making really narrow turns and hallways about 12 years ago. Anyway, so Glenwood, not a nice player. Next slide, please. Okay, so the key thing about the Glenwood was the landlord claimed at one point that they would let the service dog in if he could like lose 70 pounds, which they knew couldn't really happen. So that was like basically, not only is it illegal, it doesn't meet the standards under the Fair Housing Act, FHA, but they also knew it was ridiculous that you can't like starve a dog to death. So he does that. And there are some amusing representations at the bottom. And I point out that Glenwood, who I particularly dislike, and by the way, they used Donald Trump's personal lawyer to defend this case. The sleaze was like oozing out of the, the pleadings here. Anyway, we settled it because they knew they were going to get torched. And it was written about in the New York Post. Next slide, please. That's a photo of a dog that looks very much like Capo. Capo is actually a little larger, and I've met him and he's a wonderful dog. Next slide. What is a legal nuisance? Okay, so I've actually finished my ESA service animal presentation. I have some other slides because basically you can still encounter common law stuff relating to animals because you have, and you're not out of the woods just because you have a service animal or ESA. So I'm going to briefly consult with Jakari. Jakari, would it be better to take questions now or go through some more material?
I think we could answer a couple questions and then continue.
Okay, everybody heard the man. It's question time.
All right, so one of the first ones was regarding types of animals. I think you alluded to this, of course, along the way, but specifically our landlords required to allow any type of animal as an emotional support animal with a related follow-up of our only cat and dogs by another attendee, only cats and dogs considered service animals.
Okay, so that was recently changed to restrict certain kinds of service animals in both the FHA and the Travel Act. So for example, you can't bring a peacock on an airplane anymore, although that really happened once. And peacocks are, they scratch people. They're not the friendliest critters. So you can bring, the law doesn't place any restrictions on it, but there are other laws that must be read in conjunction. For example, in New York State, you cannot have captive wildlife in your apartment. And that's a big problem and you just can't do it. Could you go down to the slide that says Ming actually?
Which one would that be, forward?
Yes, it's forward. Anyway, there was a gentleman in Harlem who actually lived in a nice building. It's further down. More. Okay. Okay, so here's the wallet. That's Ming. Ming was living, that's a nice building right there.
Wow.
Tiger in the apartment. This happened about 10 years ago. Ming just died of old age last year in a sanctuary in Ohio. He was darted on this occasion. He lived in an apartment in a nice building with this guy who also had a crocodile, a deer, 2 pit bulls, and some other critters. And this is the punchline. He was running a part-time daycare center from his apartment. So it was really insane. And the reason that the police were notified was puddles of urine were seeping out of the apartment into the hallway. Pretty grisly condition there for the animals, the people, everybody. So you can't have Ming in your apartment, even if you claim to have any sort of disability. You can bet that nobody's going to authorize Ming to give you your ESA certificate. Next question, please.
How much does HIPAA protect towards disclosing medical information to landlords?
So HIPAA is a big issue, especially because it was just modified 2 years ago. And one of the slides here, which we didn't go to, says you should always stamp confidential subject to HIPAA disclosure protection on your on any documents you produce. Obviously, the landlord can produce these if in any court proceeding and against you. So you have to kind of be careful what you disclose, but otherwise you can, if your landlord discloses generally, basically, if you apply for, say, a service or ESA protection and your landlord posts your application and specific psychiatric diagnosis on the internet, you can sue your landlord for HIPAA violation on top of suing him for violating your rights under, the FHA or New York State statutes.
Rita has a question. I'll just encourage you to post that in the Q&A, Rita, if you can, or in the chat. I have a related question, actually, just tangential off of the types of animal or types of animals. How do you weigh the needs of a person with or tenant with a service animal of a larger size, like the case that you mentioned, against the impact of larger size animals to other tenants?
So the law says you don't. What the law does say is that the animal has to be under control and not a danger to others. So, for example, if I have a 200-pound Neapolitan Mastiff, there's nothing that prevents me from having that animal as my service animal. So what is implicit in your question is that animals are lesser stakeholders than humans in this process, and that there's some kind of unexpressed primal fear on the part of humans of animals based on size. But Capo, in my case, did nothing to arouse anyone's fear. He was a gentle giant. There are many smaller ankle biters that are much more dangerous to humans. So it shouldn't be size-based. It's a form of kind of doggy discrimination that shouldn't be allowed. And it discriminates implicitly against the person with a disability. So it's both disability and discrimination against non-human animals who I think of as non-human persons. Next question.
Sure, several more popped in just now. How will I get my animal registered as a service animal in detail?
Okay, so we were through that in some of the previous slides, and it's critical to differentiate that the person meant service animal and not ESA. If you have a service animal, that's a serious long-term undertaking. You have to get the service animal certified by locally, it's Delta Society or St. Hilda's are your two options. There are other options out of state. Some people go to literally 3-month training courses for bonding and training with their animals, because it's not just the animal that gets trained, it's the animal and the human are trained together to work as a team. Because, it's a serious business walking through the city if you're vision impaired or hearing impaired or at risk of a seizure or something. So you get that certificate, you send, and that's the big thing. After that, your application is pro forma. If it's an ESA application, that's different. I've already been over that material. So the person with the question should indicate if they meant ESA as opposed to a service animal.
Sure, we'll wait for a follow-up from them. John, how is your last name pronounced and how do we connect to you?
Okay, thanks for asking. I always feel like I'm in an infomercial if I talk about myself instead of the animals, but my name is pronounced Maher, M-A-H-E-R, and let's see, my contact information is on one of the last slides. It's like the second to last one or something. If you want to flip there, just shoot me an email is the easiest way. There's some biographical information. I used to be a animal law professor at Truro Law School. I've litigated many animal cases, and I have a particular interest in animal law and housing justice law, where I do rent overcharge in animal cases, and I don't let anybody get evicted because of their animal.
How many service animals can one have?
One per disability. You can have an unlimited number of emotional support animals, though, depending upon whether you can get certification from your physician. Some doctors, nurses, psychologists are more restrictive than others. Some will give you a prescription for like a fleet of Yorkies or something. Others will say one Yorkie or two Yorkies. You can also have different combinations of like service animals, emotional support animals, and straight up pets. I represented a fashion designer who lived in a rent stabilized apartment. It was actually a Mitchellama rent stabilized apartment. And she had a lot of Chihuahuas, and under New York City law, you're not allowed to have more than 6 dogs in an apartment at any one time. She had upwards of 12. And the thing is, they all looked alike. So she never walked more than 6 at a time. And her landlord couldn't ever figure out the difference. Anyway, and on my advice, she got one of them certified as an ESA and actually one as a service animal. And the landlord just gave up, like, trying to interfere with her.
What laws protect animals when we are applying for a unit?
Okay, the laws, there are plenty of laws that protect animals, but what we're talking about tonight, because Palante focuses on housing justice, we're talking about laws that protect humans who have, relationships with animals where those animals are part of their family and are designated in the law as service animals or ESAs. So the question should be probably better, what laws protect humans with disabilities who seek to rent or renew apartments in New York City and have a service or ESA? And the answer is that was kind of the whole presentation. And I put a very boring slide up before, but it comes down to the federal, New York State, and New York City laws, which all say you can't be, they say generally the same thing, which you can't be discriminated against or denied housing based upon any disability or status of a disability that requires a service or emotional support animal. And the language we noted, this is where it gets into boring legal stuff. The language is sometimes unclear between what the federal statute FHA means by service animal and what New York State means, which is different. But needless to say, you are protected. You are protected on 3 levels: federal, state, and city. And maybe if you want to throw that slide up earlier, it's like one of the earlier ones.
Sure, we can get back to that later whenever.
Fair enough. Okay.
Just, after a couple more, I think we have here, a client was denied, this is a little bit of a longer one, it was denied access to a DHS intake shelter because he had a small poodle, which his doctor's letter referred to as a service animal. Client had often relied on his dog to alert him to important changes in his medical condition. DHS staff was apparently uninformed and stated no dogs allowed. No answers to questions regarding where to register or certify. BRC also was uninformed on the difference between a pet and a service animal. Is there any way to make sure these staff are given the necessary information?
So I'm a litigator and trial lawyer. I usually see these things after some bureaucrat screws up and my client causes a problem for my client, and I have to like lay the law down to them. So I would say you're always going to encounter idiots and prejudiced people in life. And the main thing you can do is get a lawyer and assert your rights, because you just can't argue with insanity, right? So it helps. What I'd like to say is I'm not sure the narrative that has been described to me is completely correct, because a doctor, because the doctor in the note mentioned a service animal, but I don't see any attesting information regarding that service animal. The questioner probably means emotional support animal, but I don't want to assume that, because the question is, did that animal go through a proper training period and serve as a service animal and is designated and certified as one? So if the person asking the question can attest to that and rephrase the question, I'll focus my answer on that. Otherwise, I'm kind of just speculating.
Sure.
But the short answer is you can't be denied access to a homeless shelter based upon a service animal. And that law recently changed about 4 years ago due to a lawsuit. Next question.
Yeah, so if I have diabetes, do I have to disclose to my landlord the purpose of my dog is serving me? Some dogs are trained to protect low blood sugar.
So the question is whether your diabetes, usually it's differentiated between type 1, type 2, and other lesser forms of pre-diabetic conditions are serve as a qualifying disability if you are talking about a service animal, and whether you obtain the necessary certification for your service animal. So let's assume for the purpose of the question, which it's not at all clear if this person has, that's what the person is asking about, a service animal and not an ESA. So all you have to do is describe the nature of your disability, which could be something as general as low blood sugar. And that should be enough combined with the certificate and the physician's description.
There's an allusion there to the extent to which the individual's privacy is impacted by the information requested.
So privacy is not an absolute right in this society, sadly. And in the context of seeking an entitlement, which is you have to assert standing for that entitlement. And the standing here is that section of the Fair Housing Act, the executive law, and the human rights law all have grant standing to a specific cohort of disabled persons. In other words, not everybody who decides it would be nice to have a service or ESA can apply for one. It's designed to genuinely help people with a serious disability out by allowing them to have their animal without the hassle of, being denied and looking at a million apartments before they finally find some place that will rent to them. So in order to have that standing, you have to have a qualifying disability. If your diabetes qualifies and you have a physician's certificate attesting to that, you can get, and you have your animal trained as a service animal to specifically react in a certain way through barking or nipping or other activity regarding low blood sugar, then no problem, you're in. But you can't use a hybrid test and have a low blood sugar alert as an emotional support animal because the different criteria apply.
And that wraps up the current questions.
Very good. Thanks for ripping through them. I hope I've been able to reach out and address everybody's questions. If not, feel free to email me your questions afterwards. Okay.
Move to a different slide.
No, I think we have all our ground covered, and anything else can be a different lecture. Oh, yeah, these are just random extra slides in case I ran out of time. Don't feed pigeons from your window. It will get you in a lot of trouble. And I've actually gotten people out of trouble for feeding pigeons, but it was on a technicality. The law says you have to identify, the landlord has to identify the specific species of pigeons in the petition, and they did not. And I said, well, is it a Antwerp racing pigeon or a Bolivian homing pigeon or what? It doesn't say, it just says pigeon. Anyway, but that's a story for another night. So I guess unless there are any more questions, I'm going to thank Palante and Jakari and Robert for having me. And there's the slide with my information. My email and phone number if you need to reach out to me. Diana is listed as well. She's not here tonight. She's my law partner. And again, thank all of you for caring about your animals and for standing up for housing justice in New York City, neither of which are easy things. Okay,
Last one that kind of squeaked in here. Forgive me if this was covered earlier. Do we need to inform a landlord in advance of intent to get an ESA? Meaning I don't have an ESA now. Landlord allows animals in this building stated in my lease.
so the answer is your landlord will tell you you do. And it's the wiser policy for you to do so, but you technically can bring your animal in and then apply and still win if your landlord sues you. So I would inform the landlord in advance, just because I don't want to have the stress of I wouldn't want to have the stress of having a litigation hang over what is supposed to be like a happy moment in life. But I also wouldn't let a landlord stop me from asserting my rights to bring in an animal that would be an ESA. Also, how do you know if you have a qualifying disability and that you are able to obtain a physician or psychologist's certification for an ESA until you go through those steps? So I would try to take care of that before applying.
My pets lived in my apartment for over 3 years. Can my landlord remove my dog?
So the answer is no. New York has a 90-day or 3 months actually pet law. If you've harbored your dog in an open and notorious manner, your landlord cannot remove your dog based upon just the status of having a dog, even if there's a no pet clause in your lease. What your landlord can do, and what my landlord tried to do to me, was to claim that my dog was a nuisance. And so if a landlord can file a holdover possession and try to not renew your lease based upon claims that your dog does a number of enumerated nuisance acts, such as barking in the night or growling or threatening tenants or whatever stuff they want to make up. So it's not an absolute answer, but as far as a no pet clause, you're fine. As far as nuisance, you have to always be vigilant.
Thank you.
Okay, so I think that will conclude tonight's webinar. I want to thank John for presenting tonight and giving us so much valuable information on animal law. Thank you to our attendees for joining and asking such great questions. This webinar will be available for playback. If you have further questions or like a legal issue regarding this topic, you can call us and then we can possibly reach out to John for further assistance. Our number is 212-491-2541. So just give us a call and then we'll try our best to get you in contact with John. John, do you want to go over your contact one more time, if you would like? Or we could put the slide back up.
Sure, if you can put up the slide. I'm
Sure
John
thing.
Barr. If you have a pen and care to write any of this down, my phone number is at the end of the first paragraph, 646-675-8909. My email is John T as in teapot, MAHER@yahoo.com. And I do animal law and rent overcharge litigation in state, federal, Supreme, and housing court. So, okay, so everybody, thanks for showing up for Palante tonight. Live strong and don't let your landlords push you around. Thank you all.
Yes, thank you. All right.
So much.
We're gonna put up a quick poll for our attendees. If y'all could just answer these questions, just so, wait, not this one, sorry. This one, if you can just answer these 2 questions, just so you can help us with these 3 questions, and so we could just know how you guys enjoyed tonight's webinar would be great.